right, everybody, welcome to the interview where we try to delve into some of the more esoteric elements of the things that are making headlines across national news and ask questions that no one else is asking. The Supreme Court's new 6-3 ruling curbing nationwide injunctions has cast fresh uncertainty over the future of automatic birthright citizenship, a long-settled right now entangled in partisan fights over immigration and the limits of judicial power. But there are broader questions and implications. Joining us now is U of M legal scholar Leah Litman, author of the recent New York Times bestseller Lawless: How the Supreme Court Runs on Conservative Grievance, Fringe Theories, and Bad Vibes. Thank you so much, Professor Litman, for joining us. You're also the host of the Strict Scrutiny podcast, so you're delving into these topics, and I know you delved into this one. So what's your top-line takeaway from the Supreme Court's ruling and its implications?
I think the top line takeaway is that the Supreme Court took away what has been lower courts' most effective and potent tool to hold the administration accountable to the law and to enforce the law against the administration, and that is the nationwide injunction. And so I think we should understand this decision as a win for the Trump administration in their efforts to get out from under the host of unfavorable lower court rulings they have faced. The Trump administration has not been shy about attacking the legitimacy of the lower courts that have ruled against them. And I think the Supreme Court decision is really going to help them in that effort.
So there has been some discussion about the proliferation of nationwide injunctions as a result of lower court rulings through district court judges, and that this is a kind of a new invention, something that grew out of the 60s and seems to have also coincided with an increase in presidential power. So what about the legal scholars who say this is really just a returning to the standards in which the Supreme Court should make decisions that are nationwide, not district court judges? What say you?
So I think what that story gets wrong is that these nationwide injunctions, some scholars actually locate them in the early 1900s. So Professor Mila Sahone at Stanford Law School, for example, found an early example of the nationwide injunction in that period. And I don't think we should be surprised about the fact that there weren't nationwide injunctions for the first 100 or so years of the Republic. After all, the federal government was just doing much less then. It did not have many of the powers it has today. In fact, there wasn't really the administrative state. All of the administrative agencies like the EPA or the Department of Health and Human Services that are issuing all of these rules. And so I think nationwide injunctions were a response to a federal government that was accumulating more and more powers, including a president and an executive branch that was accumulating more and more powers. And as those powers increased, so too did the remedies that were necessary to actually stop illegal policies, when, again, a more powerful federal government was enacting them. So it's true that this is going to return us to a previous period, but it's asymmetrical in that it is returning the federal courts to a period in which they were not having the power to block policies on a nationwide basis, or they weren't doing so. But it's not returning us to a time when the federal government, and in particular the presidency, was not issuing a lot of major significant policies that affect our everyday lives.
So what about this? Could we look at this from a different perspective, that in the 19th century, there were so-called equity courts that were restraining their remedies, and that this critique of sort of an imperial judiciary, that there is some precedent for courts restraining themselves, and maybe we should look to that. What do you think about that?
So I think if we were looking to that tradition, what that would counsel in favor of would be courts assessing when nationwide injunctions were appropriate, not completely prohibiting lower courts from issuing nationwide injunctions in some cases. During the Biden administration, for example, a few district judges in Texas were issuing nationwide injunction after nationwide injunction, and there's no doubt that this practice can be subject to abuse. On the other hand, there's also no question that sometimes a nationwide injunction is probably the best fit to address the constitutional violation. If you take this case, for example, on birthright citizenship, we have had uniform nationwide rules about citizenship ever since the country was founded, and especially after the Civil War. So the idea that we need to limit the equitable powers of the courts and revert back to a patchwork system of citizenship, I think that is in many ways more destabilizing to our constitutional system than inviting courts to be more careful issuing nationwide injunctions without saying they lack the power to do so completely. And that's the path that the Supreme Court took when it came to cases brought by individual litigants.
So let's talk about birthright citizenship. The court did not rule on the merits of that very conspicuously, and yet that is sort of the greatest implication, although the president gave a pretty extensive impromptu press conference in which he noted a number of policy objectives and initiatives that might be sort of unrestrained by the actions of the Supreme Court, by the decision from the Supreme Court. So what do you see as the implication immediately, post 30 days, on birthright citizenship?
So on birthright citizenship, I think the unfortunate reality is we just don't know. The 30-day period you mentioned is because the executive order that purports to deny some people birthright citizenship says the federal government, before beginning to implement the order, will need to carry out a 30-day period in which it will announce the process and procedures and guidelines for how it plans to implement the order. I think one of the more stunning aspects of the oral argument in the case is that the Solicitor General, the lawyer for the federal government, told the justices he actually didn't know how this executive order was going to be implemented because the federal government had not yet begun the process of trying to carry it out. We don't know what the federal government is going to tell hospitals, when pregnant people come to emergency rooms and deliver children. We don't know how they are going to tell them to determine the citizenship of their parents or what birth certificates are now going to say. But we're potentially staring down a world where after July 27th, a birth certificate showing you were born in the United States is no longer sufficient to establish your citizenship. But we just don't know what will be sufficient to establish your citizenship or what kind of documentation or proof the federal government or states might start demanding of individuals, including women who are going to emergency rooms or hospitals to deliver children.
So what if there is a conflict? Like, let's just say that a state, for example, passes a restriction on birthright citizenship for the children of undocumented immigrants here in the country illegally. And there is some dispute amongst circuit courts. How would, under the Supreme Court ruling, some of that inconsistency that could show up across courts, how would that be reconciled state by state?
So I think what that would require is the United States Supreme Court to take a case reconciling, what the actual rule on birthright citizenship is. I think what the result of the Supreme Court's decision is it basically is going to require the Supreme Court to, in a lot of ways, be reviewing more cases on more questions, because what is going to happen is as these courts potentially come to different conclusions and as there is this potential patchwork of rules about who are citizens, who are not, what sort of services states can afford individuals who are designated as citizens in some places but not others, that is going to create a chaotic system in which the United States Supreme Court is going to have to intervene. Now, during the interim period, there's going to be chaos, but hopefully at some point the Supreme Court will tell us what the actual nationwide rule is.
Yeah. Do you believe that this really is something that should have been handled legislatively? Should Congress have stepped in here and prohibited lower courts from issuing nationwide injunctions? Is that something that they should have done? Would that have been the most appropriate thing to do here? Would it have been the smartest move, perhaps? And would that possibly also have been an infringement on Article 3 and equitable, powers? What do you think was the right thing to do here? And did Congress maybe shirk its duties in not tackling this, which is essentially, it seems like, what the dissent is suggesting?
Yeah, so I think in an ideal world, Congress would have made a decision about when and whether nationwide injunctions are warranted. I think short of outright prohibiting them, something Congress could have done that several scholars have proposed is, in order to obtain a nationwide injunction, Congress could have required plaintiffs to proceed in front of 3-judge panels. So instead of allowing one judge to issue a nationwide injunction, saying, no, you actually need to get the assent of 2 out of 3 judges on a panel in order to get a nationwide injunction, and maybe requiring nationwide injunctions to go to particular courts that are more representative of the entire country, rather than allowing litigants to select particular divisions where they know they are guaranteed to draw an ideological judge who is going to give them what they want. So yes, I think it would have been preferable for Congress to resolve this. If Congress had prohibited nationwide injunctions, I don't think the Supreme Court would have said that that constitutes an infringement of lower courts' equitable powers, because that's essentially what the Supreme Court determined Congress had done. So what the Supreme Court said is, under the Judiciary Act of 1789, basically the first federal law that established the powers of the federal courts, Congress did not give the lower federal courts the authority to block policies on a nationwide basis in cases brought by individual plaintiffs. And so they did not seem to think that that statutory, that congressional limitation on lower courts' authority posed a constitutional problem.
Let's go to the question of what the Supreme Court may or may not do. I mean, there was a suggestion by Pam Bondi that the Supreme Court was going to take up the question of birthright citizenship, and everyone has been questioning that because it's not on the docket, and so there's sort of like mass confusion about what this might mean. But ultimately, there would have to be a reevaluation of Wong Kim Ark from 1898 to completely overturn what has been the precedent here, right, from the Supreme Court, that because of that case, birthright citizenship, except in narrow cases of diplomatic or foreign enemy issues, that birthright citizenship is granted in the United States. So do you expect the Supreme Court to revisit this case fully? And could they just completely take a different interpretation? I mean, we have a very conservative court, and it is their right to revisit that case. Will they? Should they? And what do you think their conclusion would be?
I think it's likely that some part of the birthright citizenship case is going to go back to the Supreme Court. What that part is, however, is unclear. So as a result of the Supreme Court's decision on nationwide injunctions, now some plaintiffs have filed what are called class action suits, seeking to litigate on behalf of themselves and everyone else who is similarly situated. Once the plaintiffs obtain a decision from a lower court about whether they are allowed to proceed as a class action, that decision is immediately appealable. So whether these plaintiffs can proceed as a class action, that issue could go back to the Supreme Court rather quickly. Another issue that also might make its way back to the Supreme Court pretty quickly is this issue about whether the states that sued to challenge the birthright citizenship order, whether they can obtain an injunction that blocks the policy from being applied to anyone in their state or potentially anyone anywhere, in order to afford them complete relief from all of the harms, including the chaotic patchwork of systems we were talking about earlier. So if some lower court concludes that, yes, the states are entitled to a nationwide injunction, it's likely that the Trump administration would ask the Supreme Court to revisit that determination. Those are non-merits issues that might make their way back to the Supreme Court pretty quickly. The other possibility is, at some point, the Supreme Court reviews the legality of the executive order and whether it is constitutional and consistent with federal law for the federal government to deny individuals birthright citizenship. You're right that if the Supreme Court were to rule for the administration, that would require overruling the foundational case Wong Kim Ark, as well as many others. In Wong Kim Ark, the Supreme Court said that the children of Chinese migrants who themselves were not citizens, their children born in the United States are citizens. And in Wong Kim Ark, the parents were not themselves eligible for citizenship. So they had a legal status that is quite similar to the parents that are targeted by President Trump's executive order, individuals without legal authorization to be in the United States, people who are not lawful residents. So in addition to overruling Wong Kim Ark, the Supreme Court would also have to address a litany of other cases in which they recognize that children born in the United States are citizens for purposes of the 14th Amendment and the Constitution.
So what about that? Because the majority is basically also arguing that Rule 23 now, this class action lawsuit capability, which does become, they're arguing, really an indispensable safeguard to protect people who may want to take on these broad sweeping questions. isn't that a reasonable argument that there is some relief for people who may want to, question some of the policies of the Trump administration, and that it would have a chilling effect on any nationwide mandates or executive orders that the Trump administration would issue? Or do you see now this ruling also simultaneously eroding the ability of class action lawsuits to be a useful remedy?
So two things. One is, I think part of my concern and hesitation with the Supreme Court holding out the possibility of class action litigation as an effective stopgap or solution in the absence of nationwide injunctions is that this Supreme Court has been very hostile to class action litigation. It has narrowed the availability of class action litigation. It has made it more difficult for plaintiffs to obtain class certification and litigate cases on behalf of other individuals. Just this past term alone, the Supreme Court took up 3 cases, all of which were designed to limit class action. So that should give you some sense that the Supreme Court is narrowing this other alternative remedy such that it might not be a very effective substitute for nationwide injunctions. And indeed, in the Supreme Court argument about birthright citizenship, the federal government lawyering on behalf of the Trump administration said they would oppose any effort to litigate this case as a nationwide class action. So I have some questions and concerns about whether class certification is going to be a substitute. The second is even if the Supreme Court was not limiting the availability of class actions and class certification, that adds another procedural hurdle to the litigation and could delay the litigation in ways that might allow a policy to go into effect before the plaintiffs are able to obtain class certification. And that could be hugely consequential and destabilizing when we're talking about policies that are as chaotic and significant as the birthright citizenship executive order. Because imagine that policy goes into effect for a day or a week. We know the Trump administration is pretty ruthlessly committed to deporting individuals that it wants to target. What if it starts deporting some United States citizen babies that it deports before a court has the opportunity to certify a class and enjoin the policy as to every individual who is part of that class? So I think the legal environment we find ourselves in, coupled with the Supreme Court narrowing class actions, make me hesitant to think class certification is definitely going to be an adequate substitute here.
But does the legal and political ethos necessarily invalidate the structural ability and counterweight of class action to fight against an emboldened executive? It still is there as a structural option.
It is there, but available in theory if the Supreme Court does not allow plaintiffs to actually obtain class certification and litigate their cases on behalf of a class. In a series of cases, the Supreme Court has rejected class action theories. One of the more famous cases is Walmart versus Dukes, where a group of women tried to challenge employment practices at Walmart that they said resulted nationwide in women not receiving promotions and also being subject to mistreatment. And the Supreme Court said even though Walmart had basically a nationwide hands-off policy, they would not allow that case to proceed as a class action. So I think there are real questions about what set of cases the Supreme Court would even allow plaintiffs to litigate as class actions. You add to that this administration has been targeting lawyers who bring cases adverse to the administration, issuing executive orders that purport to penalize certain law firms or withdraw security clearances from certain lawyers. And I think that is going to diminish the pool of lawyers who might be willing to take on these big cases, try to certify them as class actions. And again, even if they're successful, the fact that the Supreme Court has been narrowing the availability of that remedy makes it available in theory, but not necessarily in practice. And I just don't think that is near sufficient or near adequate to compensate for the limitations on nationwide injunction.
How much of this do you think is just political posturing? Because it does appear that every time we come around to this, there isn't an argument to be made from either side, from the conservative or the liberal side, about what sort of role district judges should play in nationwide injunctions. Namely, the Mifepristone case during the Biden administration, where the Department of Justice there argued that pro-life organizations didn't have standing to be able to take on, even take on this issue and say that they could block what the Biden administration was doing. So in this case, the Biden administration was basically making almost a parallel argument to what the Trump administration is making. And yet at that time, you didn't see as much liberal outcry about it. And their arguments, whether they're made by the Trump administration or the Biden administration, seem to be equally cogent in each case. Is this really, do you see the diminishing of the power of district court judges to issue nationwide injunctions as maybe a returning to appropriate power and allowing the executive to do what it's supposed to be able to do?
I don't think so, and there are many things I want to say, so I will try to be quick. One is that I think that the efforts to characterize...
Go ahead, let it rip. We got another 10 minutes. Let it rip.
The efforts to characterize the nationwide injunctions that the Trump administration is subject to as similar to the ones that the Biden administration are subject to is just a kind of false equivalency. If you look at the statistics, the nationwide injunctions that the Biden administration were subject to were disproportionately, overwhelmingly, from district judges in Texas. In fact, of the nationwide injunctions the Biden administration was subject to, fewer than a handful came from anywhere outside of the Fifth Circuit, and all of them came from Republican appointees. So I think the Biden administration was the target of politicized litigation where plaintiffs were able to seek out ideological judges that they knew would basically give them whatever they want against the Biden administration. That is not true of the nationwide injunctions that have been issued against the Trump administration. Trump administration has been subject to nationwide injunctions in many of the circuits, subject to nationwide injunctions by judges who have been appointed by Presidents Bush, Reagan, Biden, Obama, and Trump himself. So I think that the nationwide injunctions that the Trump administration are subject to are not a sign of politicized litigation in a way that they were subject to abuse during the Biden administration. Now, I do think those abuses warranted some limitations, but I don't think those limitations should have been a Supreme Court just saying, let's do a flat out ban and require these to go through alternative procedures. The second thing is, I don't think this is going to solve the problem of these politicized cases being generated, by particular judges who are willing to give certain litigants whatever they want. Because what's going to happen is the next time there is a Democratic president in office, the right-wing litigants are going to go to the same district judges in Texas. They are going to seek class actions, or they are going to have the state of Texas file the case. And those district judges are going to say, in order to provide Texas the relief it needs, I'm going to issue a nationwide injunction, or I'm going to go ahead and certify a class action. And so that's going to generate the same problematic stream of effectively nationwide relief as we were seeing in a world with nationwide injunctions. And that's going to create the same sort of pressure on the Supreme Court to review all of these effectively nationwide rulings. So I don't think they've fixed the problem. And I think the problem was always lopsided as it was. The third and final thing I would say is the fact that the Supreme Court chose this moment and this case to intervene to limit nationwide injunctions is in some ways, I think, one of the worst aspects of this case. You're right, the Biden administration asked the Supreme Court to weigh in and limit the availability of some nationwide injunctions. Now, their arguments were not the exact same as the ones the Trump administration were making, but the Supreme Court repeatedly declined to take up the issue of the limitations on nationwide injunctions. They also left in place some nationwide injunctions against the Biden administration. So this issue really only seemed to start to bother them 5 months into the Trump administration. And this is an administration that is engaged in such systematic, brazen violations of the law that to choose this moment, this policy, one of the more wildly, transparently illegal policies in which to give the administration a win and to signal that its complaints against the courts were onto something, I worry is really going to embolden the lawlessness of this administration. I mean, Justice Sotomayor, in her dissenting opinion, called this, a threat to the rule of law and criticized the court for shamelessly awarding the administration's gamesmanship, seeking a non-merits ruling, allowing them to partially implement one of their more illegal policies. Justice Jackson said this court is complicit in this culture of disdain for lower courts and the rule of law, again, by basically greenlighting an administration to implement a policy when the administration has been complaining nonstop about any judicial decision that attempts to enforce the law against them. So I think for all of those reasons, the Supreme Court created other problems without fixing the real underlying problem and exacerbated others.
So the Supreme Court very notably stopped short of ruling on the constitutionality of this particular order and has now kicked it down to the lower courts, and they have to tailor their injunctive relief now. Why do you think they did that?
Honestly, I think this was cynical gamesmanship. I agree with Justice Sotomayor. There was, they wanted to give the administration a win. This is something that Justice Jackson has also accused the court of doing in an earlier decision in which the Supreme Court blocked a lower court ruling that had prohibited the federal government from freezing funds that were available for teacher training. And she said, look, the court just wants to give the appearance of a win to the government, even though it is going to ultimately lose in this litigation. And I think so too here. I think this Supreme Court is in some ways anti-Trump. It is convinced that lower courts, litigants, and others are just unfairly targeting the Trump administration, even though, of course, it's the Trump administration that is engaged in these legal violations. And so I think that they opted not to rule on the merits because they kind of wanted to curb this practice now, and in so doing, give the administration a win. The litigants were asking the Supreme Court, please decide the merits. Please request additional briefings so we don't have to face down the possibility of a world of patchwork citizenship rules throughout the country until you rule on this issue. They could have avoided that by ruling on the merits when the merits are quite easy, but they didn't. And I think that was a conscious choice to favor the Trump administration.
All right, we're getting close to the final couple minutes here. So I just have one final question for you. What about people who say the real existential threat to the rule of law is the perception of partisan judges and not the injunctions themselves? Is that a fair analysis of what's going on here? And that in some ways the Supreme Court at least tempered the ability for that perception to occur?
So I agree that it is a problem when courts are perceived to be partisan, but I think it is a deeper problem when the courts are actually partisan. I don't think that the Supreme Court's decision to limit nationwide injunctions is going to stem or address the perceptions of partisanship or the existence of partisanship. The court's decision to intervene in this case, in this moment, and now, right? I think that reflects a partisan bias. And the reality is the lower courts who are already engaged in partisan rulings, like the district judges in Texas who are enjoining Democratic policy after Democratic policy, they're still going to do so after this ruling. They're just going to do so in a different form. So I don't think the Supreme Court has solved the problem. I think its decisions just exacerbate it by showing favor to the Republican Party and the Trump administration.
All right. Well, I want to thank you so much for your time, Leah Litman, who is not only a podcast host, but also author of the New York Times bestseller, Lawless, How the Supreme Court Runs on Conservative Grievance, Fringe Theories, and Bad Vibes. We appreciate you so much for taking some time on a Sunday and for giving us your in-depth analysis of what the Supreme Court has done. We look forward to having you back very soon.
Thanks so much.
Thank you. All right, that's going to do it for the interview. We'll be back next Sunday at 4:30 sharp. See you then.